Thank you for joining us for this online event. I am Cindy Clark, Partner and National Group Head at BLG, and it is my privilege to lead the discussion today. Joining me are six of BLG's best legal advisors here to help provide insights and information during these challenging times. This is a difficult time for everyone, both personally and professionally. Of course, for Canada's frontline healthcare providers and first responders, this is a most difficult time. You have our full confidence and support. We at BLG understand the challenges and turmoil that our clients and all businesses in Canada are currently experiencing. We plan to use the next 45 minutes to help you identify and manage some of the key issues that you identified in the questions you posed in accepting today's presentation. We thank you all for your interest. I can report that we have a very wide audience and that we received many questions on a host of issues. With this in mind, along with the rapidly evolving situation in which we all find ourselves, we appreciate it's imperative to remain current. Our goal is to provide a broad overview of key issues that we think you ought to be considering and which you raised with us. In subsequent webinars, we will focus in a more detailed fashion on pressing topics or specific areas of law. Before I introduce our first guest, I'm pleased to advise all that this session is eligible for CPD credit. Following the session, you will receive an email with specific accreditation for each jurisdiction set out. We want to make the most of our time, so we're going to get started with Barb Walker-Renshaw, who is an esteemed partner in BLG's Health Law Group. Barb gained invaluable experience advising hospital leaders during the SARS crisis in 2003. While that was a different situation, there were many valuable lessons learned that we can apply today. Welcome, Barb. Barb, what lessons were learned from the SARS outbreak that you think assisted in the preparation for the COVID-19 pandemic we're now facing?
Well, thanks, Cindy. I think one of the things that really assisted is that following the SARS outbreak, there were 4 different commissions of public inquiry that reviewed the public health, government, and hospital experience during SARS. And while each inquiry had a slightly different perspective, they all confirmed the importance of strengthening Canada's public health infrastructure and with a view really to coordinating public health strategies at all levels of government and within the healthcare sector. We also have to remember that we had the 2009-2010 H1N1 influenza pandemic, and that also led to a further reviews and the development of public health emergency response plans. All of those plans and sort of recommendations filtered down to individual healthcare organizations who've developed pandemic plans for themselves to help establish sort of frameworks for key decision-making during a pandemic, things like maximizing resources, prioritizing services. When you put all of that together, I think some of the key lessons learned include, 1, information silos and idiosyncratic approaches don't work. It's important for organizations to have a uniform and collaborative response. So, for example, today, I think most hospitals have established a war room or what you might call an outbreak response team that has designated staff who will communicate practical implications of any public health and government directives to their frontline staff. The other thing I think that really came out of the 2003 SARS outbreak was the fact that, of course, it also involved a novel coronavirus. And there was a lot of debate at the time about what the appropriate measures would be because the science hadn't really caught up to how the disease was evolving and spreading in the community. So essentially, the precautionary principle stands for the idea that when you're dealing with a novel disease where the science is still new, we shouldn't wait for scientific proof to implement common sense actions that will reduce risk. In other words, erring on the side of caution is a good thing. And we see that implemented into the legislation post-SARS with that principle now enshrined in Ontario's Health Protection and Promotion Act. It requires the Chief Medical Officer of Health to consider it, especially when issuing directives that deal with worker health and safety.
Thank you for that. That's encouraging, and although SARS was challenging, good to see that some specific concrete lessons were learned. And so as you think about what our healthcare system across Canada is facing right now in front of us and in the weeks ahead, what's your assessment on the likely impact on the healthcare system of this pandemic?
That's a big question. I would say, I guess, to start, that the impact of the pandemic on the healthcare system has already begun. For example, guidance documents that were issued by the provincial public health agencies and governments started to circulate to various healthcare entities as early as mid-February of this year. Things like guidance around how they might organize and anticipate that this was coming and would become more significant in Canada in the weeks ahead. Certainly, as I said above, when we were talking about, or earlier, I should say, when we were talking about the amendments to give direction from the Chief Medical Officer of Health to healthcare entities and healthcare providers, those authorities were strengthened post-SARS to make it very clear that the Chief Medical Officer of Health could issue directives. And in fact, we are seeing those starting, and we're even starting actually in advance of the provincial state of emergency having been declared. It's important to remember that those directives have to be complied with, and some examples of those to date have been requirements that hospitals reduce elective surgeries and other non-emergent clinical activities, bearing in mind, of course, that they have to be mindful of the impact that those decisions may have on patient outcomes or patient safety. Screening measures are being heightened for transfers between hospitals, from one hospital to another. And certainly people will have seen over the last week heightened screening at hospital entrances. So in terms of future, what does the future hold? I think that is very hard to predict. Obviously, we're all very mindful of the experiences of other countries that have had very significant challenges put to their healthcare systems, and our governments and public health authorities are trying to do what they can to help us avoid that, and hence the real focus right now on the sort of collective effort to, as we're seeing, are mostly familiar with now, that expression, to flatten the curve. And flattening the curve means slowing transmission so that the hospitals continue to have the capacity to help those who are going to need admission.
Thank you. That's very helpful. Can you now give us some sense of what the scope of powers of government are once emergency measures legislation is passed? We've seen some of this unfold, but we'd like to hear from you as to what the range of powers may be.
Certainly, Cindy. Just before I talk about that, though, I'd like to note that currently, as of Monday, March 23rd, all provinces and territories of Canada have now declared states of emergency, with Nova Scotia being the last to declare a state of emergency on Sunday, March 22nd. So currently, all provinces and territories in Canada are now engaging and have declared operative their state of emergency, and therefore will have resort to that provincial emergency measures legislation. That provincial or territorial emergency legislation allows the various premiers and provincial ministers to issue orders that are aimed at mitigating the effects of the pandemic in a number of areas within provincial jurisdiction. So it's probably things that most lawyers don't think about, but there is a division of powers in Canada, and so there are certain things that fall to the federal government to legislate, and other things like education and health that are clearly within the provincial realm. So this provincial emergency legislation will allow premiers and ministers to make orders that are within provincial jurisdiction. So, for example, establishing hospitals or emergency shelters. It also gives them the authority to close any businesses, offices, schools, other facilities, and we're certainly seeing developments in that area on a daily basis. They can also limit the size of public gatherings. They can also authorize any person or class of persons to deliver services that they are reasonably qualified to provide, even if that is outside of their normal range of activities, and even if it is not contemplated for in things like collective agreements, and we're seeing that in the healthcare sector as well. Of course, they can regulate or prohibit travel within the province. That would certainly be within provincial jurisdiction. But when you want to get into things like, closing the border, restricting travelers, that is squarely within the federal realm. I would note, though, that those measures have been undertaken to date without resort to federal emergency legislation, because the federal government already has jurisdiction over that. So, for example, the restrictions on travelers gets made under the Quarantine Act, and the authority that we saw recently extended to air carriers to screen incoming passengers for symptoms of COVID-19, that involved amendments to the Aeronautics Act. So those are some of the ways that we can see, the sort of extraordinary measures that we're having or that we are seeing being enacted now. Those are the sources of that power.
Thank you, Barb. I think it gives us all a good sense of where to be watching and anticipate that there may well be additional decisions by either level of government coming our way in the days ahead. So thank you kindly for your contribution. I'm now going to call on Rob Weir to speak to us about some of the labor and employment implications of these various orders that have been issued across Canada. It's now my pleasure to introduce Rob Weir. Rob is one of our labor and employment lawyers and has certainly been very busy routinely advising clients and business owners on how to deal with a multitude of employment matters. Specifically, in the last 2 weeks, he's been very consumed with the impact of the COVID situation we're all facing. And as the papers are showing us, many are facing temporary layoffs and are pursuing the employment insurance through the government. So, Rob, can you start with helping us understand what considerations ought to be brought to bear when thinking about placing employees on a temporary layoff?
Thank you, Cindy. So a temporary layoff under our provincial employment standards, acts and codes, and under the Canada Labour Code is not a termination of employment. What a temporary layoff allows an employer to do is to place an employee off work, stop paying them, in some cases stop their benefits as well, without triggering an obligation to provide that employee with termination pay or, in Ontario, for instance, severance pay under those statutes. So it provides employers with a bit of breathing room in this environment. The rules vary from province to province. Some provinces have more restrictive rules around temporary layoffs. In BC, for instance, a temporary layoff must be found, the right to do it must be found in an employment agreement or a collective agreement or an industry practice. But in most other provinces, employers simply have a right to lay off people on a temporary basis. In Ontario, for instance, that period can be 13 weeks in a 20-week period, or it can be much longer. It can be 35 weeks in a 52-week period where the employer puts an employee on a sub-plan, for instance, or continues their benefits. At the end of the temporary layoff period, however, an employee who is not recalled to work is deemed to be terminated, and at that point, the obligation to provide severance pay and termination pay then kicks in.
That's helpful. So that gives us a flavor of some of the statutory considerations. I've also understand that there are continue to be discussion about some concepts that we've heard about around constructive dismissal and those kinds of things. Do those considerations still apply in this environment?
So it's a good question. So in the common law provinces, that is all the provinces outside of Quebec, and my colleagues in Quebec tell me that there's less of a risk of a constructive dismissal in this circumstance in Quebec. But in the common law provinces, and there's case law in Ontario that says in normal times, a temporary layoff, putting somebody on a temporary layoff, although perfectly permitted by the Employment Standards Act, is a constructive dismissal for common law purposes. In our view, however, there's been some interesting academic commentary in the last 2 weeks wondering whether a court will step in and say, well, there is actually an implied right in a pandemic to put an employee on a temporary layoff at common law as there is under the statute. And there's a huge litigation risk now to employees to commence a claim. If an employee is laid off on a temporary basis and then sues his or her employer, but is recalled to work 6 weeks later, for instance, that the period of damage for that employee is only those 6 weeks at common law. And so it's just not worth it for employees to sue in this environment. And the courts are closed across the country right now, so it's very difficult to get a claim issued in this environment. So it does provide employers with a bit of breathing room. Employees will be able to apply for employment insurance, and if they meet the criteria, they will qualify.
That's good to know. And in addition to the employment insurance, is there anything else employers can do to minimize the impact of temporary layoffs on their employees?
Sure. So employers at this time should be doing everything they can to protect their employees. Their mental health is obviously under strain at this time. And there are options under the Employment Insurance Act. For instance, an employer can put into place a supplementary unemployment benefit plan in this circumstance. We think of those plans being provided to parents who go on parental leaves or women who go on pregnancy leaves, but they are available in these circumstances. An employer must apply for that program and be approved. In addition, there is a job sharing program under the Employment Insurance Act, which permits a group of employees to agree to share their jobs. So effectively, it permits an employee to be laid off for 2 weeks, receive EI, and then go back to work while his or her colleague is also on layoff. So those are some things that employers should think of. The job sharing plan, unfortunately, is not the most user-friendly. It requires some online application, and that's being difficult at the moment, but we're hopeful the federal government will streamline that program. Other options you can think about that are not a temporary layoff. Think about reducing pay across the board. Think about reducing hours of work. Much as you can do to keep your employees working, that's great. And of course, we've all thought of this, and we're all doing this now. In the professional services area, people can work from home, and that allows them to keep working and avoids a temporary layoff.
Very helpful. Thank you. And you just mentioned the opportunity to keep working, and yet I know a number of provinces have recently announced that they are insisting that on all non-essential workplaces close. So can you help us understand what that means and what an essential workplace is considered to be?
So that's a great question. So as everybody will know across the country, but certainly in Quebec and Ontario, as of midnight last night, only essential workplaces were permitted to be open. And each province has published a list of those workplaces. And the list in Ontario, quite frankly, is quite expansive. It wouldn't be right to call this a lockdown or a shutdown. There are 74 categories of essential workplaces under the Ontario list. But if your business is not on one of those lists, you need to be shut down today. That doesn't mean your business needs to be shut down. You can't have people going into work, but that doesn't mean that you can't have people working from home. Teleworking and online commerce are permitted at all times for these businesses. So in other words, close does not mean quit, and you can still work from home as much as possible, but you need to be checking those lists, and certainly other provinces will be following suit. We expect in the days to come, but you need to be checking that list and making sure that your business is not on it.
Right, I understand, and this probably is something that may evolve as things move forward. So Thank you very much for that, Rob. That was really helpful.
right.
Appreciate you joining us this afternoon.
Thank you, Cindy.
It's now my pleasure to introduce Eloise Graton from our Montreal office. Eloise is an internationally recognized expert in the field of privacy, and she regularly advises businesses on all kinds of data management, cyber risk issues, and privacy concerns. So welcome, Eloise. We're wondering if you can start this afternoon by helping us understand a particular concern for many employers at the moment and businesses. Can an organization in the current environment of dealing with this pandemic share personal health information without consent in the context of this public health emergency?
That's a good question, and we can probably think of two types of sharing. So I would probably have two answers for you. The first type of sharing is probably within the organization. So businesses across Canada can generally disclose personal information without employee consent when it's necessary to respond to an emergency that would threaten someone's life or someone's health or security. There are some exceptions. For instance, Quebec doesn't have that consent exception, but elsewhere you do have that consent exception. Also, given that employers are subject to occupational health and safety laws, generally they are required to take reasonable measures to provide a safe work environment. So I think this means that they could probably be justified to disclose personal information about an employee affected by COVID-19 to the extent that this sharing would be necessary to provide a safe work environment. When relying on these consent exceptions, employees concerned must usually be notified before the disclosure. On the second type of sharing, which would be a sharing of personal information with public health authorities, a business who received a request from a public health authority to disclose specific information about an employee will usually benefit from a consent exception. Again, it depends on the jurisdiction, but generally speaking, that's the case. So upon receiving a request, the authority on which the request for disclosure is based should be verified. So businesses should not be necessarily taking these requests at face value. So they must ensure that any disclosure is justified by law, it's limited to what is necessary to achieve the goal behind the disclosure, protecting, the citizens against a health crisis, and also that it is documented in sufficient detail. It probably makes sense for businesses to implement written policies and procedures concerning the management of personal information related to COVID-19 and make them available to relevant stakeholders, employees, clients, and so on.
That's very helpful. Thank you. And in order to be in a position to disclose it, of course, a business needs to know that an employee has a COVID-19 positive test or any other particular illness, but let's focus on the issue at hand here. So can an employer actually request or demand that an employee share that information? And if not, can the employer, or in addition, I should say, can the employer insist that an employee undergo testing so that the information can be made available if they don't have it already?
The short answer is it depends. Currently, given the fact that the pandemic has been declared a public health emergency in a number of provinces, and that employers are generally required to preserve the health and safety of their employees, I would say that they may be justified in collecting some type of personal information related to an employee's exposure to COVID-19. So we can think of an employer requiring them to disclose whether they've recently traveled to an affected region, been in contact with a person that has contracted the virus or been diagnosed with the virus. However, given that health information is usually considered sensitive, employers ought to exercise caution and limit their collection to what is necessary. So, for example, many employers are looking to require that employees undergo periodic testing or screening, such as temperature checks. Before doing so, they need to consider the reliability of the testing process. And they should always weigh the benefits from the practice against the impact it may have on their employees' privacy. They should also consider whether there are less privacy-intrusive alternatives that may achieve the same goals and that are available to them. Another quick point to keep in mind is that under Canadian privacy laws, businesses must collect and use personal information for purposes that are reasonable and legitimate in the circumstances. So that notion of reasonableness does not lend itself to a one-size-fits-all approach. It must be evaluated on a case-by-case basis. So while a practice may not be considered reasonable or appropriate today, it may become reasonable, in the future, depending on the evolution of the pandemic, and vice versa. Also, in other words, the answer as to whether a certain practice is legal is a moving target that should probably be periodically reassessed.
That's very helpful. Thank you. And now, why don't we shift gears a little bit, because the prior answers really focused on being in circumstances where an employee is actually coming into a premises to engage in work. We have many now businesses and organizations who have individuals working remotely. Can you talk to us about what organizations should be doing at this time to address the cyber and information security risks triggered by these remote working arrangements?
Well, many businesses have had to rapidly adapt to the present situation by allowing their employees to work from home. So the result of this is that their IT infrastructure and systems may be vulnerable to cyber attacks. So just to give an example, in recent weeks, we have seen a large number of phishing emails related to COVID-19 that were specifically designed to take advantage of the mass disruption and confusion caused by the virus. So it's imperative for businesses to stay ahead and take proactive steps to reduce the risk of a successful cyber attack. So these steps may include reviewing and updating policies and procedures relating to information security and incident response to ensure that these documents reflect potential issues related specifically to remote working conditions and the heightened risk of cyber attacks. Monitoring and logging network-related activities to and from an employee's network and encrypting transmissions containing personal information through a virtual private network is quite important. I think educating and reminding employees about applicable information handling security practices and how to detect these phishing emails and how to report cybersecurity risk within the organization is increasingly important. Limiting access to personal information to employees who have a legitimate need to access it for the purpose of their role or function within the business, within the organization. And probably another key issue would be implementing multi-factor authentication measures and other access-based security features. You can think of a periodic password reset. These types of security measures are expected by privacy regulators, so they are important if businesses want to be able to demonstrate diligence in the event of a security incident impacting personal information.
Thank you very much, Eloise. Certainly lots to think about in these times. We much appreciate your assistance. Thank you. It's now my pleasure to introduce Rob Dean. Rob is one of our partners in our Vancouver office, and he's a leading commercial litigator and barrister in terms of international and domestic arbitrations, dealing in particular with a range of privacy and intellectual property litigation. So Rob is very well suited to talk to us about some of the key contractual risks and disputes that are arising in the current environment. Rob, we're hoping that you can start by explaining a few words and phrases that have been in the news lately. Can you help us understand what force majeure is and how it differs from the concept of frustration?
Thanks, Cindy. Force majeure simply refers to a contractual term in which the parties have agreed that in certain situations, one or both of the parties will be excused from performing their obligations under the contract. Now, there's a few key things, I think, to remember about force majeure clauses. First, their scope depends on their specific terms. There's no standard rule. Some are broad, some are narrow, some exclude pandemics, others include pandemics, some apply to any contractual obligations, some are limited to certain contractual obligations. There really is no freestanding definition, so you have to look at your particular contract. Second, a force majeure clause will typically excuse a party from performing its obligations when a particular event has, for example, prevented, hindered, interrupted, or delayed a party in performing those obligations. The key to remember is that its function is to temporarily excuse what would otherwise be a contractual breach entitling the other party to sue. Flowing from that is really a third point, and it's this. Well, there are exceptions in which a force majeure clause may result in the termination of the contract, at least after a period of time. The force majeure clause is typically not such a complete get-out-of-jail-free card. It applies only during the period in which the event is really being experienced, and it only applies to the particular contractual obligations that are being impeded. But as you highlighted in your question, Cindy, it's important not to become solely focused on force majeure clause. Other common law concepts may also be relevant, and one example is one that you mentioned, which is the doctrine of frustration. Now, a contract may be frustrated whether or not a force majeure clause is present or is satisfied if it has become impossible, simply incapable of performance because of external events. So you can see the test is higher than most instances of force majeure. Also, and this is another important difference, the usual consequence of an act of frustration is that the contract is brought to an end, not just put on hold. So it's really important to be very clear about what type of provision is being invoked in a particular case, and it's especially important to ensure that you're giving notice of the right thing. You don't want to, for example, be taken to have terminated a contract if all you really want and need is simply a pause in your obligation. Of course, the reverse may well be true. You may need and want a complete termination, but what you want will affect what you declare. And it's important to be precise in that regard.
That's very helpful, Rob. Thank you. I also understand that there's a concept of mitigation of loss or damage. And can you help us understand how that, if at all, interacts, if it does, with the concept of force majeure?
Well, mitigation is a label. I always find that one easy way to think about it is this. When a contract goes sideways, there's a general burden on the parties to simply take reasonable steps to minimize the consequences of that problem for the other party and, in fact, for both parties. So in other words, and putting it simply, don't take the chance to run up the losses. So I think you should always be alive to reasonable steps that can be taken to reduce or eliminate the burden if you are the party thinking of claiming force majeure. Because quite frankly, if you can take reasonable steps to eliminate it and you fail to do so, it may not be force majeure at all. And if you're on the other side, you can't just throw your hands up and be done with it when the other side claims force majeure as a general matter. There should be, in all cases, a serious discussion about ways in which contractual performance can be adjusted to minimize those adverse consequences. As I say, you can't just throw up your hands and be done with it.
Interesting. And what about the implications of government-ordered closures? So help us understand if those same concepts apply if it's a government-ordered closure, and maybe you can use an example of a lease to help us understand the implications.
Well, I mean, this is obviously a huge issue for both landlords and tenants. What happens when your business is ordered to close down, or from the landlord's perspective, you're ordered to bar access or to stop servicing completely a building where your tenants' businesses are located? The first thing to observe, and it's important to step back, I think, is that these broad closure orders that we're seeing and will likely continue to see are unprecedented. Many of the consequences, I think, are likely to be solved by one-time programs, legislation, other orders, or even insurance. Or realistically, simply practical accommodations between landlords and tenants. There's only so much that the law of contract can practically do to deal with unprecedented and hopefully once-in-a-lifetime situations. But with that caveat, just looking at the lease as a contract, the first thing to do is to assess whether there's any force majeure clause in there. And if there is, in what circumstances is the tenant excused from performing its obligations? And one of the big ones, of course, is the typical obligation of continuous operation in the retail context. What does the force majeure clause say about that? And from the other side, in what circumstances is the landlord excused from performing its obligation, especially the obligation to grant access and quiet enjoyment of the property? What if the landlord is prevented from the order from granting access at all? Now, to cut to what people are really concerned about, in our experience, And I think it's fair to say that many commercial leases actually specifically exclude an abatement or limitation of rent from the consequences of a force majeure clause. In other words, these type of leases that are quite common provide that the tenant may be excused from all of its other obligations, continuous operation and the like, except for the obligation to pay rent. But as I said at the beginning, that's not the end of the story. Whether you're a landlord or a tenant, you should always consider other contractual doctrines, such as the doctrine of frustration, which I spoke about in particular circumstances. And it's important not to develop tunnel vision and focus only on force majeure. There are other concepts in play.
And if parties, whether it's a landlord and tenant or other parties to a contract, aren't actually able to negotiate these situations into themselves, what's your impression of how the court closures that we've seen across the country are going to practically affect parties' abilities to pursue a remedy that they may think they are entitled to?
Well, I mean, that's what really matters. All of the advice about legal rights is nice, but you need a forum in which to vindicate those rights or they aren't worth very much. So you have to have that ability to seek a binding resolution. Now, as a constitutional matter, courts can't close completely, and they don't and they haven't. But they can issue directions that they'll only hear truly urgent matters until the crisis is over. And most courts made those calls last week. So we've had those underway for quite some time. The result is that you can still have access to the court, but you'll have to demonstrate why it's truly urgent, akin to the end-of-life decisions, injunctions, and similar matters that the courts have identified. And even then, you'll be having a hearing by conference call. Now, we've done those in the past few days in several offices, so it can certainly be done. But again, go look at your contract. I think it's highly likely that you'll have an arbitration clause in that contract, particularly if it's an international contract, so a contract with parties from two jurisdictions. And the good news there is that most arbitral institutions have provisions in their rules for emergency arbitrators who can be appointed and make decisions, in our experience, within 24 to 36 hours in some cases. And arbitrators and arbitration counsel are also experienced with written proceedings and remote hearings. That's nothing new in arbitration. So court closures don't affect arbitration. I guess my overarching message there is that you shouldn't be completely discouraged from what you hear about these court closures. Contracts still matter, and there's still ways to enforce them. Those ways may just become a little different for the next little while.
Thank you so much. That's very helpful, Rob. Thanks for joining us. So I'd now like to introduce Joel Jones. Joel is a corporate lawyer who's regularly advising businesses and corporate clients on a whole range of issues and business matters, negotiations, drafting, commercial agreements, and certainly acquisitions and divestitures. And he's here this afternoon to talk to us about what he's seeing in the business from a business perspective. So, Joel, welcome. And I'm wondering if you can tell us what you think the top issues are that you're seeing that your clients are addressing at the moment.
Sure thing. Happy to. The issues that I'm thinking about at the moment are really the ones that are critical to allowing businesses to survive through these unprecedented times. So therefore they are primarily linked to such things as revenue, financing, costs, and vary, of course, from trying to determine if clients have the capacity to utilize or avoid force majeure and material adverse change provisions, or enforcing contracts related to financing, to determining the impacts of laying off staff or implementing survival wage decreases, determining whether they can claim business interruption insurance under their insurance contract, or even obtain rent relief under leases, things of this nature. These are the types of issues I've been helping clients through with the assistance of our other subject matter experts like Rob Weir and Rob Dean and others within the firm, of course, at the moment anyway.
That's helpful. Good to know and makes sense given everything that we've heard. And I did neglected to mention in your introduction that you hail from our Calgary office. So recognizing that you are from Alberta, can you give us your thoughts on the impact of the low oil prices at the moment, combined with the COVID-19 situation, What's your assessment of the impact on the Canadian economy?
You know, there is absolutely a double concern in Alberta, and certainly the oil and gas industry has been hit extremely hard by the combination of these two storms colliding. No question about that. But given the revenues that the energy industry generates for the country, I believe that this is really a national concern rather than one that is limited to Alberta or the West, which I think is evidenced by the fact that the federal government has recently announced intentions to implement a multi-billion-dollar relief program for the industry. Now, we will have to see what the details of this program are and if this stimulus program has a desired effect. But obviously, the hope is that the timing of this will assist in reducing the overall impact of the perfect storm on not only the oil and gas industry, but also the entire Canadian economy as a whole. So it is still early stages, and of course, we will just need to wait and see how things unfold at this point.
Well, hopefully there is the right assistance in the right way from government. So thank you for that. Recognizing all those challenges, what are your thoughts on what steps a business should be pursuing and thinking about to weather this perfect storm?
Obviously, cost cutting is critical to surviving the current economic conditions, and we've actually been engaged to do comprehensive contract review for a number of our clients to assist them in trying to find every opportunity to reduce payment obligations and risk wherever possible. It's I can't reinforce enough. It is extremely important right now for businesses to be proactive like this and undertake these types of exercises at this time.
That's helpful. So it sounds like you might be anticipating a slowdown in corporate activity, but do you also think it might be a time when some companies might be thinking about seeing this as a bit of a buying opportunity? What's your assessment? Perhaps a little bit ahead, but looking forward, what do you see?
You know, I think there's going to be a definite slowdown in activity until people can begin to digest everything and start to get a handle on how long this is going to last. There's just so much uncertainty at the moment. All new corporate activity is essentially paralyzed right now. That being said, I think there will be unparalleled opportunity as we start to come out of this, and I think we will see a rush of M&A activity as companies with access to capital try to seize upon that opportunity. We have actually already been having meetings with clients who are starting to strategize and take steps so they're in a good position to capitalize on this opportunity once things start to stabilize a little bit.
Great. Thank you so much, Joel. It's nice to hear that bit of optimism at the end there, so we'll hang on to that. And thank you very much for your thoughts this afternoon.
No, my pleasure. I do think there's some hope on the horizon, so it's all good.
Thank you. And for our last speaker, it's my pleasure to introduce Kate Crawford. Kate is one of the partners in our health law group. She works with our healthcare clients on strategic support and helping them navigate a whole range of issues, and has been involved in a number of crises. Not, of course, the particular one is just evolving that we're dealing with, but she's been through enough with enough healthcare organizations to know the importance of crisis communication and strategy. So thought she would add some value to our conversation this afternoon. So Kate, welcome. Based on your experience, I'm wondering if you can provide some key insights about risk management in particular with regard to managing COVID-19 for the audience.
Hi, Cindy. Yeah, I'd be happy to. The key risks will obviously depend very much on the nature of your business. But if we step back when we think about COVID-19 risks specifically, businesses will need to balance their business continuity risk with the risk to public health and employee wellness. The nature of that balance will depend heavily on your business, really. That balance in a healthcare setting, for example, is very different than the balance in an office environment or a sales environment or a manufacturing environment. There are both legal and reputational risks in getting the balance wrong. The precautionary principle, which you heard Barb speak about earlier, is an important principle to apply even in your risk management approach. Be conservative and assume that the ground will continue to shift underfoot.
That's really helpful. And we know that people have many demands on their time and many issues they're trying to address dealing with this current situation. But can you help us understand where risk management and crisis communications ought to fit in? What are the consequences of putting those issues to the side during a crisis like this?
We all know how tempting it is to streamline inputs when we're dealing with a crisis and to try and limit the number of voices or the noise in the conversation. But putting risk management and crisis communications to the side isn't the right choice right now for an organization. The principles that are going to be brought to the table by your risk and communications teams are important and a really textured part of your crisis response. These are the teams that are going to help you ensure that your employees are safe, informed, and engaged. They're the teams who are going to help keep clients and other stakeholders up to date on your response. And that ultimately is going to create the stickiness in your relationship with your clients and staff. The risk of ignoring these principles is alienation. We know that when we alienate our staff and our clients, we ultimately are bringing to bear more risk around business interruption and litigation, ultimately.
Thank you. And now, appreciating and being reminded of the importance of having good crisis communication, who do you recommend? What type of position within the organization do you recommend be on the crisis communication team?
Generally speaking, it's my advice that your team should have subject matter experts who can speak to the groups who are most impacted by the crisis itself. In COVID, depending on the nature of your business, that may be occupational health and safety, it may be your HR team, it may be your business leadership. We recommend having a communication lead who can present a calm and thoughtful narrative or theme to the public, but who has access to subject matter experts to address specific questions as they come up.
Thank you. And now if we think to messaging, do you have a few things, maybe 3 would be helpful, that you think businesses ought to be including and considering in their messaging to both their employees and to their clients and customers?
Sure. Our focus at BLG in the recent weeks and months, I suppose, has really been on maintaining calm, thoughtful, and relevant communication, both with clients and employees. When we find ourselves in a crisis, people really crave information, and there's often a glut of information available, but the reliability is highly variable. Those people who have the information struggle to distinguish reliable from unreliable information while they're trying to share it as quickly as they can. The risk, of course, is that information is disseminated prematurely, without validation, or in a way that's either alarming or alarmist to those receiving it. We also have to remember that we communicate very differently with our employees than we do with our clients. So we need to be really particularly careful about what we're sharing and with whom when everyone's moving so quickly. Ultimately, I guess if I had to bring it down to 3 concepts, my advice is always to be calm, to be thoughtful, and to be relevant.
That's great advice, Kate. I think it's good for a crisis communication team, but probably good for each and every one of us as we navigate the days ahead. Thank you so much for your insights.
My pleasure.
We want to thank all of you for your participation today and, of course, to our speakers for their insights. We hope that you found this valuable and that you will join us for future webinars that are of particular interest and importance to you. Thank you again, and be well.